debate will transform.
We have had some problems with the induction loops, which I am told have now been sorted out. But if anybody feels the need to come and sit in the front of the court so they can hear properly, please feel free to do so. And may I ask everybody with a speaking role to keep their voices up. Mr. Burton, we have read the skeleton arguments and the judge's judgment, and we have looked at the impugned parts of the guidance.
My Lord and my Lady, I'm most grateful for that indication. What I'd intended to do was to take you to the guidance and the specific stipulation in relation to minimum curb heights, only briefly to make a couple of observations which are relevant to the submissions of the appellant and indeed by way of almost sort of preemptive strikes in relation to the submissions of the respondent. Obviously, there's a discrete question here about what the purpose and impact of this particular stipulation is within that guidance, which I think probably requires a little focus. Beyond that, I was simply going to really rely on the judgment below in terms of the description of the facts, making a couple of observations about the documents that perhaps weren't picked up by the learned judge below, before then developing the submissions reasonably swiftly, I would hope, for the reason that they're fairly straightforward and set out in the skeleton. And then, of course, if there are any particular matters that are troubling the court, I can perhaps deal with those by way of reply after the court's heard from Mr. Williams. Well, with that in mind, I ought to make just one other point about the second statement of Ms. Franks, dated the 5th of October 2023. There is an outstanding application by the respondent to rely on that. Initially, it's correct to say that the appellant objected to that because it wasn't clear on what basis the respondent was seeking to rely on both the statement itself and the exhibit. I confess at that stage I hadn't seen my learned friend's skeleton argument on behalf of the respondent. Having now seen it, I take no objection to that evidence at all. It's plainly useful background information, if nothing else, to the court. And I may make one or two observations.
At the end of all this, there'd probably better be recorded in an order that we have given permission for the statement to be
recorded. My Lord, I'm grateful. So as I indicated a moment ago, if we could turn up the guidance, and of course by the guidance I mean the tactical paving guidance, or guidance on the use of tactical paving services, which is in the core bundle, beginning at page 164. And I wanted to take you, if I may, to the introduction, beginning at page 170. On behalf of the appellant, we've collectively called the two aspects of guidance, the guidance. You will have picked up, doubtless, that the relevant stipulations that we're concerned with appear in the tactile paving surfaces guidance and are then carried over, as it were, into the inclusive mobility guidance. And so I see no reason at the moment to take you to the inclusive mobility guidance at all. So then just coming then to the introduction at page 170 to the tactile paving guidance, just to highlight a couple of important points. Under 1.1, why is this guidance important? It's described as being a guide to best practice on the use of tactile paving surfaces. So it's setting itself a relatively high bar in that regard. It then reinforces why the use of tactile paving surfaces is important because they convey vital information to vision impaired and other people about their environment. And then again reiterates why that's so if it isn't obvious enough in relation to vision impaired people. Under 1.2, what is this guidance based on? We say the language here is important and indicative that this is a document which supersedes the previous guidance. So the exercise here is producing guidance that replaces the pre-existing guidance, which is no longer of any effect. And then the second sentence just reiterates that this guidance superseding the previous does not alter the principles set out in the original guidance document, which explained the background and how it was developed. And true it is, but otherwise this is, for all intents and purposes, we say fresh guidance issued by the Secretary of State.
So the decision, you characterise the decision as a decision to issue new guidance.
My Lord, absolutely, yes.
if the decision were characterised in respect of curb height at any rate as a decision not to change the old guidance, would it make any difference?
Well, as a question of law, probably not, because there would still be a decision not to do something, as it were. But the manner in which the decision was expressed might be different. And we say that for this reason, that there can be no doubt at all that as far as anybody who's reading this guidance, or indeed being directed by this guidance, is concerned, they will consider this to be the Secretary of State's considered position at the time that it's promulgated on the 10th of January. And therefore, insofar as there's anything else there that might be said to conflict or can compete with this best practice guidance, the Secretary of State's position is clear, that this is, as it were, the final word. Subject, of course, to what the Secretary of State says about potentially reviewing it in the future, but we say nothing rides on that from a legal perspective. It's not what the Secretary of State occasionally seems to characterise this as a question of sort of omission, just leaving something as it is untouched for a period in light of changing circumstances. This is a clear decision to intervene in a scenario in which guidance has previously been promulgated and issue new guidance, albeit new guidance which doesn't differ in all respects from the previous guidance, or in the material respect that we're concerned with. Under 1.3, what does the guidance cover? As of course we know, it deals with 6 different types of tactile paving surfaces, which I'll come back to in a moment. But it is important to stress in the appellant submission what's said at the bottom of page 171, that this guidance is intended to be suitable for application to a wide range of common situations. And then under 1.4 on page 172, who is this guidance for? Public and private actors and individuals with a role to play in the provision, design, improvement and maintenance of the public realm. So of wide application, not specific, for example, to identify public authorities and such like, but of much broader application. And then the second paragraph under who is this guidance for references the duties under the Equality Act, which of course impacts both public and private individuals. The use of this guidance will support the processes of creating and maintaining an inclusive and acceptable built environment and activities carried out in compliance with the PSED and Equality Act, and indeed reasonable adjustments. Furthermore, under 1.5.1, inclusive design, again, just underscoring the importance of this guidance in that second paragraph. The guidance should be referred to from the outset of any public realm design or maintenance scheme. And the other reference under that heading I wish to highlight from page 173, the sentence of the first full paragraph. An inclusive design approach should also be applied to relatively small, localised or routine public realm improvements. At the specific heading under the Equality Act and Public Sector Equality Duty 1.5.3, obviously sets out the law that you'll be very familiar with in terms of PSD and such like. But just if I could invite you to look at the final paragraph under that heading 1.5.3 on page 175, the provision of tactile paving as described in this guidance will show good practice in the creation and maintenance of an accessible and exclusive built environment and public realm. So there's a clear understanding in the guidance that deploying the guidance will work towards ensuring compliance with equality obligations under the law. So, my lady, my lords, if I could then turn to the relevant stipulation in relation to minimum curb heights. We see it introduced under the first of the 6 relevant surfaces, which is blister surfacing, which is at point 2, which begins at page 179. and obviously the blister surfacing itself is to be used at designated pedestrian crossing points, and its purpose is twofold. General purpose is to provide a warning to vision impaired people who, in the absence of a kerb upstand greater than 25 millimetres high, may otherwise find it difficult to differentiate between where the footway ends and the carriageway begins. The implication being there that if it is 25 millimetres or higher, then such difficulties would not arise. But what is the meaning of that statement in the context of the overall guidance in relation to blister surfacing? Well, that becomes a little clearer when we read further down, if I may. The third paragraph, while the absence of a kerb upstand at crossings is essential for wheelchair users, some users of walking aids and some other people with buggies or trolleys, it is potentially hazardous for vision impaired people who generally rely on a kerb upstand as a warning that they have reached the edge of the footway. The surface, that's the blister surface of course, is therefore an essential safety feature for vision impaired people at pedestrian crossing points where the footway is flush with the carriageway. Next paragraph, where level access at a crossing is achieved by means of a dropped kerb rather than a raised crossing, the base of the dropped kerb should preferably be flush with the carriageway but can have a maximum upstand of 6 millimetres, provided that a rounded bullnose is provided at the interface with the carriageway. And insofar as it helps, if you pull down, you see in the next figure what that guidance is speaking to. Now, the appellant's reading of that guidance is this, that what it's concerned with is ensuring that there are forms of level access crossing for people who require level access crossings, people, for example, in wheelchairs or who have other mobility problems. And such a level access crossing implies an upstand of 6 millimetres or less, otherwise it would present a physical obstacle to people using wheelchairs and such like. In that sense, the reference to 25 millimetres and the minimum required kerb is superfluous, one might say, to this piece of the advice. The advice could simply have said, where you have a level access crossing, you must ensure it's not higher than 6 millimetres and you must put in blister paving to warn people who are visually impaired and won't otherwise be able to detect the 6 millimetre height. There's no obvious need in that part of the guidance, we say, to go further than that and stipulate what might be considered a safe maximum height for kerbs generally. But the guidance nevertheless chooses to do that. That isn't, of course, the only reference to the 25 millimetres. We see that also further on, again dealing with blistering. If I could ask you just to turn to page 193. You'll see under the heading of additional layouts, the guidance then goes to deal with a number of different permutations of the blister paving with a great deal of stipulation about how and when it ought to be deployed, most of which is irrelevant for our purposes. But if I could invite you to turn up page 202, which is where we see the second reference to the 25 millimetres. We're dealing here with vehicle crossovers and vehicle accesses. Here it says, under general layout, at all vehicle crossovers, a minimum 25 millimetres upstand should be provided between the carriageway and the vehicle crossover. This upstand should help ensure that the vision impaired people do not inadvertently venture into the carriageway. So again, we see the reference to 25 millimetres, but being very squarely anchored to the needs of one particular form of road user, namely the vision impaired.
There is a slight change from the old guidance.
There is.
Which said ensure, and this one says help ensure.
It does indeed. not something that the Secretary of State's relied upon, and there is this question about how this guidance might have been softened or qualified by caveats that is quite important to the appellant's case. We say that's not enough there. It's not a distinction of sufficient significance, and certainly not highlighted in such a way as to be material to the issues in this claim. But yes, it's acknowledged that there is a slight difference there. But when measured against the first reference that we looked at a moment ago, where we do not see such a qualification, we see something more categorical, that over 25 millimetres would not cause difficulties, we say the combined effect is one and the same. This is a clear stipulation based on a judgment, which one would assume, reading this guidance, is based on some form of evidence or some form of assessment, which, as we know, it is not. For completeness, if I can just finish on this point about why this is in the guidance at all, which may be relevant ultimately to where we find ourselves on the legal questions. We see, as I've already taken you to that first reference at the top of the page on 202, and then the guidance draws a distinction between vehicle crossovers with high traffic flows and those with low, and high traffic flows as examples of petrol filling stations, shopping parades, supermarkets, car parks and whatnot. So these are crossings coming across the pavement, as it were. And then those with low traffic flows, which are for sort of residential addresses and whatnot. And the significance of that is that if, as we go on to see under 2.5.5, it's only in relation to those where there is significant, sorry, not under 2.5.5, under those headings 2.5.4, where we see that if there is heavy traffic flow, then there should be blistering, and if there isn't, there need not be. The significance of which, of course, is in areas where there is no low traffic, or there is low traffic, as deemed by whoever is reading this guidance, there will be no blistering. There will only be the 25 millimetre kerb, which, if that proves to be undetectable, would mean for blind people there is no effective warning at all that they're about to cross over a carriageway, albeit one which is low traffic. And we see further utility given to the 25 millimetre stipulation under 2.5.5, which is talking about where rather than lowering the kerb, you raise the carriageway. And we see at the bottom of that page 202, where an extensive area of the carriageway has been raised, it is not appropriate to install the blister surface along the full length of the raised area. In those circumstances, the blister surface should only be applied to the main crossing points. Where the remaining interface between the footway and the raised carriageway is flush, or has an upstand of less than 25 millimetres, it is vital to ensure vision impaired people are not able to stray inadvertently into the carriageway. This could be achieved by creating a level difference between the footway and carriageway of at least 25 millimetres. So there again we see clear reliance on the judgment of a technical nature in relation to 25 millimetres being deployed for the single purpose, it has to be stressed, of protecting vision impaired people, not seeking to strike some balance between different road users as such. So, my lady, my lords, that's the relevant stipulation embedded within the guidance. I shall, if I may, refer to it as the stipulation and the guidance as being the general guidance, just for the purposes of my submissions this morning, and in order to make it clear what I'm speaking to at various points. I'm sure this point is not lost on you, but why is this important? Is set out in various different places. One rather neat place is where it's set out by Miss Lewison, the lead researcher at the Inclusive Public Spaces Unit, European Research Council project. You have the statement in the bundle. I'm just going to give you the page reference for your note. It's at paragraph 26, page 224 in the supplementary bundle.
Sorry, give me the page references again.
Page 224 of Miss Lawson's statement, paragraph 26, where she just neatly summarises the various safety issues that arise in relation to kerb heights that are potentially undetectable by vision impaired people. And I'm sure most of them will be common sense. You'll understand, of course, the principal one is straying inadvertently into the carriageway. a point she doesn't make, but I would suggest can be made just by reference to common sense. Of course, that risk to visually impaired people is obviously a very real one and a very present one and has material significance in terms of legal implications of itself. But of course, this is a greater danger. This is dangerous to people using the roads more generally. People are straying into carriageways without knowing they're doing so. Then obviously drivers and others are equally at risk, and other road users. The point I wanted to make, again, it's a somewhat obvious point, but I just want to make this absolutely clear, is what's said, in fact, by Miss Franks in her first statement at paragraph 54, page 40. Again, I'm just going to read it out. It's not.
Sorry, can we just have the references more slowly, please?
Apologies. It's paragraph 54 of Miss Franks' statement. This is her first statement at page 40 in the supplementary bundle.
Thank you very much.
Yes.
She just underscores the point I made a moment ago, or indeed is clear from the guidance generally, which is this, that the challenges associated with crossing curbs led to a long-standing position in the department's advice and guidance that flush crossings, such as those when the curb and footway are reduced to the level of the carriageway, should be provided at regular intervals to assist mobility impaired people, wheelchair users and other street users, including those non-visible disabilities and those with prams and buggies, to move about safely and independently. And again, I know the point is obvious, but it's important, I think, to keep it in mind that curb heights are there for various purposes, including in order to ensure that visually impaired people can detect the carriageway from the curb. And then the interests of people who have difficulties with curbs have been met in long-standing guidance by having periodic, regular level access crossings. The 25mm is not a product of some form of balancing exercise between those who have difficulties with curbs and those who are visually impaired. It is squarely directed towards protecting the visually impaired by ensuring the curb is detectable. And that indeed is the aspect of the guidance that is considered to be so dangerous by the three visually impaired organisations that are supporting this challenge, all of whom say 25mm is too low, and all of whom made that point to the Secretary of State in advance of this guidance being produced, for the reasons I mentioned a moment ago, but the obvious one being an undetectable curb is essentially the same as being no curb at all. My ladies, my lords, the next important document that I was going to take you to briefly, if it will assist, is the UCL study that was done in 2009.
Can I, before you leave the guidance itself,
of course, my lord. Can
I just ask you about page 170, which you began with?
This is, yeah.
I just wanted to be clear that I've understood this correctly, because I may not have done. It's the bottom two paragraphs where it talks about updating, including responses to some recommendations of research. And in the final paragraph, in the middle of that final paragraph, it talks about the negative effects of tactile paving on the experience of wheelchair users and people with walking difficulties.
Yes.
I may not have understood this correctly, but I just wonder how that relates to the submission you made a moment ago about how the 25mm figure is not the product of any balancing exercise.
Yeah. Well, first of all, the identification of what the purposes of the 25mm stipulation is clear from the words used when introducing it. That's my first point. The second point is the aspect of the guidance that my Lord refers to is something which arises independently from the work that was done in relation to the guidance generally. which was that too much use of various forms of tactile paving can have unintended consequences for other road users. And throughout the guidance, there are attempts to minimise the extent to which it must be used. It's not obvious that that has any bearing on the legal questions in this case, because there is, for example, one form of tactile paving, a seventh example, that was dropped altogether between the previous guidance and the current guidance, because it wasn't felt it was really achieving any purpose, and therefore it was a form of tactile paving that was there unnecessarily and potentially causing problems for other road users. But if it has any impact on the 25 millimetres stipulation, it's not obvious to me, save for the fact that, of course, if in a particular scheme or a particular road design somebody was intent on using pavements which were below 25 millimetres, there would be a problem about how they...
Curbs, do you mean?
Yes, curbs.
You said pavements.
I do apologise. Curbs of 25 millimetres or less. Then it might be said that they would be coming into conflict with that broader principle set out at the bottom of page 170, because they would then have to put in list of paving. And yes, maybe that's a problem. Maybe even that would act as some form of deterrent. But I think it is important to understand this, and this certainly to some extent explains the concerns of the charities I mentioned a moment ago, that this 25 millimetre stipulation is the only guidance across the board from the Secretary of State dealing with the question of how high do curbs have to be in order to be detected by visually impaired people. And as you will have seen from the evidence, and is incontrovertible, that has become a much bigger issue between 1998 and 2022 because of a tendency to try and produce what are sometimes referred to as shared spaces, which we absolutely accept this guidance is not addressing, but that doesn't necessarily mean it doesn't inadvertently influence how designs of shared spaces are developed. And you will have seen potentially, and obviously I was going to come to this in due course, that at the moment there's a moratorium on shared spaces that are level per se, like absolutely flush. There's not a moratorium on shared spaces where lower curbs are being deployed. And low curbs have been a feature of such spaces throughout, and that's clear from the evidence, and in due course I was going to give you the references for that, which, for example, demonstrate that curbs that have been set at 30 millimetres, so higher than the 25 millimetres, have been shown to cause problems for visually impaired people. And so, to put it bluntly, the concern of these charities and others is that in such road design projects, developers will have the reassurance of this guidance and the stipulation in relation to 25 millimetres when designing curb heights more generally. So they might keep them above 25 so as to avoid any excess blister surfacing, but not necessarily high enough to ensure that they remain detectable by visually impaired people. That really is the gravamen of the issue from the perspective of those charities. My Lord, does that address...
Yes, thank you.
My Lady, my Lords, I mentioned a moment ago the point being made about how this issue has become more important since 1998. I'm just going to give you the references for that while I do that, so I don't have to repeat myself later. They're actually in paragraph 9 of the appellant's skeleton argument. In particular, Miss Alukam's statement on behalf of Guide Dogs UK, which is her witness statement, paragraph 4, supplementary bundle, page 158. And then, perhaps in the fullest sense, by Miss Fothergill from the RNIB, is her witness statement, paragraph 16, which is supplementary bundle 176. and indeed Miss Gayton has also given further information about that at paragraph 3 of her statement, supplementary bundle 137. And in due course, I'll give you the references for problematic projects which have involved low but not level access kerbs, which are indicative of the problem concerning those charities. My Lady, my Lords, in relation to the UCL study, nothing about it is particularly controversial in the sense that I think we all know what it said, but it might be useful just to look at it briefly. It's in the supplementary bundle and begins at page 226. 226. This is referred to variously as either the Pamela study, the UCL study, or by reference to the authors, Childs, etc. I'm sorry about that. It's just referred to in different ways in the various different documents. We've referred to it as a UCL study, but in some other documents it's referred by those alternatives that I mentioned a moment ago. Under the executive summary on page 229, you will see in the second paragraph that this in fact was a second study carried out by the Pamela Research Unit at UCL. The first one was solely concerned with the question of whether or not 30mm high kerbs were detectable, and that's referenced in that second paragraph. If you pull down to, I think, the fourth sentence beginning, as part of that research,
Yes.
Research programme in 2007. I wonder if I could just invite the court just to read to the end of that paragraph.
So there they're saying, are they, that the 30mm kerb height was the worst of both worlds because it was still a barrier for wheelchairs but wasn't good enough for visually impaired?
Yes, effectively. And indeed, I mean, I think it's uncontroversial to say that that conflict exists as soon as you have a kerb of anything beyond 6mm. So the way in which that particular problem has always been resolved is by having these regular intervals for level access crossings, which is precisely why the reference to 25mm isn't the product of a balancing exercise, but is in fact solely concerned with detectability by visually impaired people. But what is important in my submission here is that this research in 2009 is building on the previous research, which is effectively already ruled out 30mm as being too low, and then goes on to see, well, what might be safe over and above that then? And I mean, we can jump straight to the conclusion on that at page 255, which is the result of their study. Where they effectively say 60 inspires the greatest confidence, 40 is problematic for a significant number, and further testing should be done around 50. Just scrolling upwards, if I may, briefly, experiment limitations. These were always fully acknowledged by the authors of the 2009 research. In general terms, they're referencing the fact that these were done in laboratory conditions, but also, of course, that they were only concerned with identifying detectable kerb heights for visually impaired people. It doesn't purport to be a study into something broader than that, which does have some significance. as I'll seek to demonstrate in due course. There is just one other aspect I don't want to avoid, which is actually looking at a bit of the numbers at page 240. You see a table there where this was solely about detection.
Wasn't it? 240.
240, my lord. And you'll see there are two tables there dealing with stepping down and stepping up the kerb. And generally speaking, stepping down was more problematic than stepping up in terms of detectability. And we see the kerb heights on the left, and then whether or not the kerb was detected before going up or down it, whether it was on the kerb itself, or importantly after the kerb, i.e. after you've already stepped beyond the kerb or stepped up the kerb. And the reliability or otherwise of the various kerb heights is assessed primarily by reference to failing, i.e. just simply being oblivious altogether. But of course it's also important to keep in mind in terms of road safety the relative numbers of those which are only detected, as it were, after the event, after somebody has stepped down and stepped into the carriageway. It is common ground that this is the only research that was available to the decision maker as regards detectable kerb heights at the material time. And that point is simply reinforced by the exhibit to the second statement of Ms. Franks that the local authority, sorry, the Secretary of State has introduced alongside Ms. Franks' second statement, which reiterates that this is the only evidence there is on the question. My Lady, my Lords, the judgment at paragraphs 12 to 18 then deals with the various reports that were produced between the UCL study in 2009 and the guidance promulgated in January 2022. If I may, I was just going to offer a couple of additional references in relation to some of those reports, in case it assists. In the skeleton, you have the page numbers in the bundle for the individual reports, should you wish to look at them directly. And it may be that Mr. Williams takes you to some of those, and it may be that in reply I need to deal with discrete points arising from them. But generally speaking, from the appellant's perspective, the judge analyses those accurately and in a way which the appellant takes no issue with. A couple of points, if I may, though, in relation to the Holmes report, which is the one that you'll see referenced at paragraphs 13 and 14.
Of your skeleton?
Sorry, no, that's 13 and 14 of the judgment.
Of the judgment.
It's in the skeleton at paragraph 11A.
Well, you should just take us to whichever bit you want to look at. Anyway, 13, 14 of the judgment.
Yes. Well, in light of what I'm going to offer here, which is a couple of additional references, you might wish to put them next to the skeleton at the relevant paragraph, if that's a convenient way for you to take a note of those. That's how I've done it for purposes of my own note.
Right.
There's not very many.
Let me just turn up your skeleton. Yes.
So on Holmes, just for the record, that this was a report prepared on the basis of various surveys, etc., which covered 100 shared space schemes. That's at page 260. And the general point being that people's experiences of these were sort of collectively negative, but there are references at page 268 to the particular impact on visually impaired people. And page 269 of small or low kerbs. And then the statement made at page 261, I probably should have taken first, apologies, is that the most controversial issue arising from these shared spaces schemes has been the removal of kerbs. It was the issue that was most prominent in the responses. The next report is the report of the Women and Equalities Committee, which was a wide-ranging report looking at a number of discrete issues pertaining to disability in particular. And in light of the responses they received as part of their inquiry, they did a discrete piece of work within that report on shared spaces schemes. And as the skeleton highlights, as indeed the judge did, that generated a recommendation, which was that the government should require local authorities to call a halt to the use of shared space schemes, pending clear national guidance that explicitly addresses the needs of disabled people. This should, in particular, instruct local authorities that controlled crossings and regular height curbs are to be retained, and that they should undertake an urgent review of existing schemes. The next report in chronological sequence was from the Chartered Institution of Highways and Transportation, which we see in the skeleton at subparagraph C. Where it effectively relied upon the UCL study to surmise at the end or conclude that a curb height between 50 and 60 millimetres would appear to be suitable, but further research on this topic in the field is needed to inform this key design decision. That was then followed, again chronologically, by the Disabled Person Transport Advisory Committee, set up to provide advice to the Secretary of State, where that committee strongly endorsed the recommendations of the Women and Equalities Select Committee, seeking a pause on shared spaces schemes. And indeed, DeepTAC made submissions or responses, I should say, to the consultation carried out as part of the lead up to the guidance, where they too said that the 25mm stipulation should not be repeated in the January 2022 guidance. Now that did result in the government introducing a pause to shared spaces schemes, which is dealt with in subparagraph E as part of the inclusive transport strategy. And where it was generally said, as the skeleton indicates, that in light of those existing reports from WEC, CIHT and DeepTAC, there should be a pause, and that was in order for there to be further research and guidance on the question of shared spaces. In the footnote there, it references, but without the page numbers, unfortunately, which I'm going to give you in a moment, what in fact the Secretary of State did, which was to write to local authorities in August and September 2018 respectively, saying that any new schemes, i.e. schemes that had not yet reached the design stage and which concerned level surfaces only, should be paused. And the references are, for those two letters, supplementary bundle 151 to 152 and the September one 155 to 156. As we know, the government then commissioned Transport Research Laboratory Limited to do the work on what should or should not be included in the new guidance. And that ultimately led to the decision in the second of its reports, produced in February 2020, referenced in paragraph F. And the quote there at the end, the question of whether 25 millimetres remains an appropriate boundary between what is not flush should be subject to further consideration.
But it doesn't seem to be saying it should be discontinued.
No, it doesn't say that at this stage. It's an asterisk put next to the 25 millimetres. So my reading, for what it's worth, of that particular recommendation, because ultimately it changed, was that they were saying you needed to have this reference to a minimum curb height to make the guidance work, but you need to look at whether or not 25 millimetres is the correct figure. If you see what I mean.
I do, but what are you supposed to do in the meantime? Do you make it 0, or do you do something else?
Well, I will come on to that. I'm not going to duck that issue at all. Right. But at this stage in the process, this is only February 2020, this is 2 years out from this guidance materialising, they're saying you've got to do some more work on this.
Yes.
And indeed, ultimately, we do know that further work is being done on curb heights, and we see part of the reason for that at G in the skeleton, which references the jointly commissioned work by Transport Scotland and the department, which produced the Inclusive Design in Town Centres and Busy Streets Areas report published in February 2021, so a year later. And if we just have a look at that, that's at Supplementary Bundle 111. So this was recommendations coming under the general heading of Principle 13, segregation, and is squarely concerned with the lot of disabled road users generally, as is explained in 8.51 and 8.52. And then we see the recommendation, which is under 8.52. Further quantitative research is recommended to define the curb height provision with and without tactile demarcation, taking into consideration all types of disabled street users. The research approach should consider the level and type of disability, level of personal adaptation, and degree of personal assistance, as well as street conditions. The research should seek to identify the curb height to support access for the majority of users, 85% being an indicative figure. So yes, this would include, one would assume, analysis of what curb height is detectable by visually impaired people, but is a much broader piece of research trying to identify the needs of all disabled people and road users, and then one presumes the extent to which there is any conflict there and any balance that needs to be struck. And then the PAMLA research, or the UCL research, is then set out thereunder, and not in any way criticised as such, but of course we know the PAMLA research was looking at the narrower question of detectability for visually impaired people, so not sufficient to meet the recommendations made as part of that report. And obviously, as we know from Ms. Frank's most recent statement, we are still awaiting the outcome ultimately of that research. We know that alongside that work, the work of TRL continued. There was the consultation that was a subject of the discrete challenge, which was accepted by the judge below. I'm not going to take you through those responses, but I just wanted to take you to one which, in my submission, is sort of indicative of what, in particular, the visually impaired charities suggested or represented to the Secretary of State. If I could ask you to turn up page 202 in the supplementary bundle, please. Now this follows on from the separate workshops that were had with the various stakeholders. Some criticism is made about how much time they had. Then at the bottom of page 202, we're extremely disappointed to find the continued reference to 25mm as the minimum detectable curb height for blind and partially sighted people, underscoring that they're an essential safety feature for people who with sight loss. The fact that the Pamela study had been brought to the attention of the Secretary of State and how it had been referred to by other forms of research, etc. And then the point underneath that, the 25mm recommendation does not appear to be based on any evidence. And with our considerable expertise, RNIB believes an upstand of 25mm is unlikely to be detectable. To continue to have the 25mm minimum will mean more street designs using curbs which are not reliably detectable for people with sight loss will be built, potentially endangering lives. In our view, both guidance documents must be updated to 60mm as a minimum detectable curb height, as that is what the best evidence we currently have says. If 25mm recommendation is based on evidence, please could you provide us with this evidence? Of course, as we know, although that request was made all the way back in May 2021, we still haven't seen any evidence, and it appears to be the acknowledged position that there isn't any. It's slightly unclear whether or not there ever was any, but there certainly isn't any that the court can review at this stage, or indeed anybody else could engage with it at that stage.
Mr. Burton, just in the immediately preceding paragraph, there's a reference to a judicial review case in Northern Ireland.
Yes.
Is that in our bundle?
The decision to include it, the decision was made not to include it, in fact, because it was...
You refer to it in your skeleton argument, but
yes.
I don't think we've been provided with it.
No, and of course you can be if it would be helpful.
On your submission, is it helpful? One way or the other?
No, it's just an example of a decision maker deciding that that was the best evidence and deploying it. Of course, that doesn't mean the Secretary of State was bound to follow that, of course. What is in the evidence, however, is...
sorry to interrupt, Mr. Burton. Is that the decision that's quoted by the judge in paragraphs 44 and 45 of the judgment?
My lady, it is, yes.
Yeah. But you don't think we need to see it?
No. I mean, what is in the evidence, which I was going to give you the reference for very shortly, is what the problems that the particular 30mm curb that was being deployed in Northern Ireland in that instance gave rise to the judicial review, which then gave rise to the decision that 30mm was effectively in breach of the PSED. But our case is not, I mean, obviously, the Secretary of State hasn't had regard to the UCL guidance or has ignored it. That's not our case. That was largely the case, as I remember it, in the Northern Ireland case.
And do you say it's irrational to consider that further research is needed before making a recommendation?
Well, that's the Secretary of State didn't do that. The Secretary of State made the recommendation.
That wasn't my question.
Sorry, I perhaps misunderstood it. We certainly do say, we say two things in a nutshell. We say that the straightforward breach of tame side is this is a stipulation based on nothing, and it being of a technical nature, it needs to be based on something. And then on rationality, we say effectively, not that this is a binary choice between 60 and 25, but that 25 clearly has no rational basis, is irrational, and the only evidence they had was that at least 30 millimetres was going to be necessary, and therefore 25 was not open to the Secretary of State. We don't put it any higher than that. We're not saying it had to be 60. There was a separate discussion with the judge, and it's referenced by the judge in the context of consultation challenge, about whether or not at least the stipulation could have been expressed in a different way, which was not, which said, well, on the evidence that we've seen, this is what we think it should be, or indeed, left the question entirely open to other decision makers and referenced the evidence. There are a number of different possibilities.
Well, that's what I'm trying to get to, the practicalities.
Yeah, sure.
Here we know there has been guidance in place for many, many years with 25 millimetres as the recommended kerb height.
Yes.
The Secretary of State seems to take the view that more research is needed.
Well, some research is needed, in the sense that, in relation to 25 millimetres, yes.
Yeah, more research is needed. In the meantime, there is guidance out there. So what does the Secretary of State do? He can leave it alone and say, I haven't finished my Tameside inquiries yet. He can withdraw it and provide no guidance. He can do something else. So, I mean, it's the practicalities that I'm interested in. Mm. Which I think is a point that my Lord Justice Singh was really putting to you.
Yes.
Should there be no guidance at all?
Yeah. If I may, I put my submissions this way. First of all, we demonstrate whether or not 25 millimetres itself is a tenable stipulation. It's a technical recommendation or stipulation and is read as such and referred to as such in best practice guidance. If it's not based on anything, it can't be promulgated, full stop.
But the logic of that would be that you have nothing.
No.
If everything is quashed, then there's nothing there.
No, my lord, it's not. The rational answer is to go, what's the best evidence we've got?
Right.
And the best evidence is 25 millimetres is too low. Now, the next question is, okay, what do we do instead? That's not one I believe I need to answer. I don't need to go that far in order to demonstrate that people shouldn't be building kerbs at 25 millimetres. Now, what the Secretary of State does in that context is a different matter. And various discussions were had with the judge below about what might have been the practical solution, but they were in the context really of relief, not really in the context of whether or not illegality has been established in the first instance. And I do think for the clarity of thought here, we do need to address that question first. We mustn't mix the two and say, oh, well, there's a practical problem here. If the decision is made, we're going to say 25 millimetres is safe, then it has to be based on something. And if it's going to be based on, well, we've had 20 years of it without problems, that would have been one way of approaching it. That's not what the Secretary of State decides. Indeed, that would have been untenable in light of the weight of evidence that was put forward that low kerbs, including kerbs that aren't necessarily as high as 60 millimetres, but are be up 25 millimetres, are causing problems. And in my submission, we must be very careful not to be tempted into the trap of saying, well, there was a bit of a practical problem here, and ultimately the Secretary of State is muddling through. The other option would be to be completely upfront about this and say, this is what the guidance has been up until now. We're reviewing it. We don't necessarily think it's reliable. And then allow other decision makers to make their own determinations. Instead, we see something very different in the guidance. We say, follow this and you'll largely be in compliance with your Equality Act duties. The complete opposite of what the judge ultimately found, which is, well, this can all be solved by others. In the context of how this advice is expressed, guidance, sorry, that's not a tenable conclusion in our submission. So long as we proceed on the assumption that I must first establish whether or not 25 millimetres is an unlawful stipulation, then I think we can then have a secondary conversation about perhaps what would be the rational thing for the Secretary of State to do, and indeed what relevance that might have on the question of relief, should we get there.
I may have missed your submission, so can I just be clear?
Yeah.
Are you saying that the burden of proof is on the Secretary of State to demonstrate that the 25 millimetres is based on evidence?
Well, I must confess, I haven't put it that way.
Oh.
I mean, the only piece, ultimately, we haven't needed to, because the Secretary of State hasn't got anything to support the finding. And indeed, it's clear in the interactions with RNIB and others that the Secretary of State doesn't know the answers to where 25 millimetres has come from, so we must proceed on the assumption that it's not based on anything. We rely on the refugee action case as being, albeit its first instance, but it's a demonstration of the principle that each decision must be looked at on its own merits. And we say the same about this guidance now, the 25 millimetres. What we were more cautious about is saying precisely what the Secretary of State should have done in light of the fact that 25 millimetres was no longer tenable. What everybody else has done, and we now know this, everybody else, let me rephrase that. Those that we know of and identified in the document that's appended to Ms. Frank's second statement is they've taken the cautious approach and adopted what UCL have done, pending better evidence should it materialise. I mean, ultimately, whatever the deficiencies in the UCL study, it was addressing at least a discrete question of what is a minimum detectable curb height for visually impaired people, and there's nothing else.
I mean, the judge does say in paragraph 9 that the Secretary of State wasn't able to adduce evidence about how the figure was calculated, other than to say that it was based on research. No further details of what that research entailed were in evidence.
Yes, the guidance, not the recommendation. We know nothing about the recommendation at all, the stipulation.
Well, maybe I'm misreading paragraph 9.
Well,
it seems to suggest that the Secretary of State's position was that although the evidence didn't exist anymore, the original minimum curb height of 25 millimetres had been based on research.
yes, I apologise, you're right, that is how he expresses it. My recollection was, and this was only based on submissions, there's no evidence in the papers, was that the guidance itself was based on an evaluation, but we didn't have anything specific about the recommendation. But, I mean, if we are to infer that it's some evidence, the difficulty for the claimant and the charities is, well, how do we go about identifying whether that evidence is better than the UCL evidence? And we obviously know the Secretary of State hasn't done that. The Secretary of State hasn't made that comparison exercise either, because it doesn't know what the evidence is. So on the premise that the rational decision is one which is based on evidence, the only evidence, or the best evidence, whichever way you put it, is the UCL research. And what the UCL research, we say, establishes without equivocation is that 25 millimetres poses serious risks. Let's put it that way. And what we don't see is any form of risk assessment by the Secretary of State. There is no evaluation of what risk comes with 25 millimetres. There is no appreciation, which is a point that I was going to develop in due course, about, all right, well, even if this was based on something, we don't know what it is. We've got the UCL research and we've got these representations. What level of risk are we prepared to entail, or are we prepared to encourage others to entail by deploying 25 millimetres? Now, there's nothing to that at all. The principal reason given by the Secretary of State is they didn't consider the UCL evidence was robust enough to cause them to displace the 25 millimetres. But that presupposes, does it not, that the 25 millimetres is based on something equally or more robust. And what, in my submission, the cases demonstrate, in particular in relation to the context of PSED, but generally, is that one should be careful of relying on inferences. One should be looking for evidence in order to discharge the burden of informing oneself as to the equality implications, real or potential, of a particular action. This case would be very different if the Secretary of State said, well, this is what we have done. We've looked at the evidence of whether or not 25mm has caused any problems in the last 20 years. We can find none. We're content that it's been unproblematic. We've got this one piece of research which suggests in a hypothetical scenario it might be. We're not prepared to rely on that to depart from our previous judgment. There is nothing of that kind in any of the paperwork. All the Secretary of State says is, well, we're going to do some research and we might look at this again in the future. But the meantime, it matters. As Ms. Grayson points out in her statement, this guidance is already being used. We don't know specifically what that entails. We can't put the evidence that far. But as one would expect, this guidance is being used in the manner that it's intended to be used as best practice across the various domains that are highlighted when we looked at that paragraph. I freely accept that my case would be more difficult if it would be sustainable at all, if the Secretary of State had done what I just mentioned as the relevant exercise, or instead had qualified by reference to appropriate caveats the 25mm stipulation. A possibility that the judge himself at paragraph 61 considers. But having set himself the task of determining what is a detectable kerb height, and then promulgating guidance which says categorically it's 25mm, that's a task that, as a matter of law, requires evidence, or at least an evidential basis, if I can put it that way. And the underlying proposition that having accepted more evidence is needed, a decision maker can nevertheless do the very thing that more evidence is required in relation to, simply because there's a commitment to review it in the future, is not a recognised principle of law or a recognised exception to the Tameside duty. It's not clear, it's not explained why the guidance couldn't, for example, just reiterate the existence of the UCL study.
So can I summarise the point, see if I've understood it?
Certainly.
You say that once the Secretary of State has accepted that more evidence is needed, it is wrong, it is unlawful to make a positive, unqualified recommendation before that evidence is complete.
Well, yes, except that it's not necessarily just based on the Secretary of State accepting it. We would say as a question of law it was objectively necessary. And that being the case, it was wrong for the Secretary of State to promulgate the guidance in the manner that he did.
There is evidence in the sense that there is a lot of research which the Secretary of State has considered, both the UCL study and the various interim reports and the transport laboratory study and so forth. So there is plenty of evidence, but it's not yet complete. At least it hasn't got to the stage of making a recommendation.
Well, the discrete question, which is what we're focusing on here, and it's important about detectability, there is not a lot of evidence. There is the UCL research and that's it. So the problem for the Secretary of State is, well, we don't necessarily think this evidence is going to be determinative in the long run because we think we might be able to improve upon it. But it necessarily calls into question whether or not 25mm is correct. So you may have picked up from the refugee action case, for example, that in a slightly different context, of course, the Tameside duty may be reinforced if you're effectively put on notice of an issue. Same under the PSED. If you're given reason to believe something requires further consideration, which is relevant to what you're purporting to do or proposing to do, then you may have a freestanding obligation to go and do that. And the Secretary of State, to that extent, has acted appropriately. But what it's not appropriate to do in the meantime is supersede the guidance with new guidance and pretend, as far as everybody else is concerned, that this stipulation is based on evidence in some way which supports it, when it isn't. And no one reading that guidance could possibly understand that that's the case.
But suppose you're right. Suppose you're right about that.
Yes.
In public law terms,
Yes.
surely what would then happen is that you'd continue with the old guidance in the meantime.
In my submission, no, because that's not what the Secretary of State did. If the Secretary of State had openly said, look, we've got this guidance, we're not changing it now, even though we've got good reason to believe it may well be wrong, and that's going to be our considered position to readers of the guidance, then, as I've said a moment ago, we'd be in a very different position. But that's exactly what the Secretary of State doesn't do.
No, I understand that, Mr. Burnham. I'm sorry. I'm asking you not about the facts.
Yes.
I'm asking you about the conceptual analysis
Yes.
of what would happen as a matter of public law.
Yeah.
If you're right,
Yeah.
then why isn't the scenario that you revert to the old guidance? If the new guidance is flawed on public law grounds, why don't you then, as a matter of law, go back to the old guidance while the further research is done?
Well, because the old guidance has been shown to be irrational, because on any view, it's not one that's open to the Secretary of State on the basis of the current evidence.
So then, as a matter of law, do you submit that there ought to be no guidance at all, and it's left to other decision makers?
As I said earlier, I don't believe I need to go that far. I simply need to go as far as saying is that the guidance in relation to 25mm wasn't open to the Secretary of State.
It seems to be where you end up.
Yes.
Because there should be no guidance.
Well, not necessarily, because as I've already said, you could either have caveated the 25mm appropriately, or you could have taken the best evidence available to you and reached a different conclusion. And in my submission, that's not going to be as low as 25. And in reality, it's probably going to be at least 30, because the evidence in relation to 30 seems incontrovertible. I can't imagine, and I'm not required to imagine, what the product of a different exercise conducted by the Secretary of State might have looked like, where they tried to gauge the balance of risk in relation to that. But we just don't see it. What we do know is the Secretary of State can't presume that 25mm is rational simply because it's been the guidance. The Secretary of State has an obligation to review the material put before it. So, my Lord Lord Justice Singh, I understand why you're asking me the conceptual question. It's very hard for me to answer that without going back to the facts to some extent. And if the Secretary of State had taken the view that bits of this guidance would be caveated in the way that I've suggested, it would be clear to the readers of the guidance and the content of the guidance and what it seeks to achieve is ultimately the subject matter of this challenge, that they themselves should not rely on 25mm as being definitive. It's not explained why that hasn't been done.
Well, forgive me, one of the curious features of this case, at least to my mind, is that although you succeeded on the consultation ground, the usual consequence which follows from such success didn't occur, and it appears that you didn't press for it, because at paragraph 62 the judge says that you realistically accepted that success on ground 2 was not sufficient to quash the guidance. And the reason why it may be significant in the context of the grounds that you are now pursuing may be this, that see, the normal, correct me if I'm wrong, the normal consequence of a breach of procedural fairness is that the court quashes the outcome, because the outcome has been reached by an unfair procedure. The court doesn't know what the outcome would have been or would be if there's a fair procedure, and so the court simply quashes the outcome, and therefore in law it's a nullity. You pretend that it never existed, and then the consultation has to take place again, but without the court presupposing what the outcome of the consultation will be. Now, if the normal situation had occurred, then it seems to me at least that what would then have happened is that the old guidance would have continued to exist unless and until a new consultation process, which was fairly and properly conducted, resulted in new guidance. So, I mean, do you agree that?
Absolutely, yeah.
So far, you agree?
Yes, the learned judge below didn't really accurately record the full extent of the submission.
Right.
So our submission was, we knew that new research was potentially going to be available. At that stage, we were being told it would be available this year. What we said to the judge was, in relation to all the grounds, what we would be seeking ultimately was the first instance of declaration, at least because that would achieve the purpose of telling everybody that this aspect of the guidance was unreliable and shouldn't be followed as a matter of law, and then to give the Secretary of State an opportunity to make submissions about how long it would take to fix it and how it should be fixed. And we've repeated those submissions before this court. Unfortunately, we weren't given permission to appeal on the discrete question that we raised in our notice of appeal in relation to the relief that was granted and the nature of the declaration that the learned judge ultimately did make. But yes, it's right to say that we didn't say it automatically should lead to a quashing, because we were seeking to be as pragmatic as possible. We wanted to ensure that on the one hand, those who are going to be influenced by this guidance understand that this particular stipulation shouldn't be followed, at least until further notice, and give the Secretary of State an opportunity to try and remedy it with the risk of a suspended quashing order in the circumstances. We were unclear at that stage, I think it's fair to say, my learned friend may have a different view, about when we could expect the further research. And so it was a degree of a pragmatic concession. The aim here is a pragmatic one from the perspective of the claimant and these organisations. Something has to be done to ensure that those devising these schemes understand that 25 millimetres is not a rational statement as to the proposition, which is what minimum heights are detectable by blind people based on the evidence that we all have. You know, we're all using the only evidence that's available. Where I believe there's problems is if we start to pretend the Secretary of State hasn't really superseded the guidance with fresh guidance and has simply decided to be passive and say, well, we're not going to do anything for the time being. Now, that might have been another option. They might say, well, we'll just wait. And the learned judge did, of course, rely on the fact that this guidance contained many other factors that needed to be publicised as being a reason why he found that the actions of the Secretary of State were rational, but without, in our submission, properly first addressing whether or not there was a fundamental breach of the Tameside duty in the first place, which was how ultimately my submissions would have been developed in front of you had it been necessary to do so this morning. It may not need to be anymore because it's fairly clear what our points are. I mean, it is a technical stipulation expressed as such on a specific discrete question that is not based on any evidence. I mean, if you look at Tameside itself, I mean, ultimately what the House of Lords concluded in that case, having looked at all the evidence, is it all distilled down to a single question that had not properly been answered by the Secretary of State, namely whether or not the reluctant teachers would come on side once the Secretary of State had refused to interfere with the decisions of the local authority. We say ultimately you can apply the same analysis to this. In light of the UCL evidence and the absence of any evidence supporting 25 millimetres, did the Secretary of State properly address the question of what is a safe minimum kerb height in order to be detectable by visually impaired people? And there is no evidence that that exercise was carried out. And there is something problematic on the one hand saying we're going to issue this guidance saying 25 millimetres, but with our other hand, we've already decided that we need more evidence on what is a minimum detectable kerb height for visually impaired people. Can you have your cake and eat it in that context? So the Tameside, just to finish off, the Tameside submission on ground 2, we say would be capable of being made even if it wasn't for the UCL evidence, because it's based on nothing. And the Secretary of State doesn't purport to base it on experience over the 20 years period or anything of that kind. What the UCL evidence does do is, we say, make the Tameside duty even more acute in the manner that it's dealt with by Mr. Justice Popplewell in the refugee action case. There was a body of evidence which suggested the previous determination that they were intending to repeat was wrong, and therefore that made a need for a careful inquiry. And at the very least, the UCL study does that, alongside the representations made by all 3 of the visually impaired charities. And the slightly different analysis in relation to rationality is that in the absence of any evidence, 25mm is not tenable. If the decision is made, we've got to say something, then you've got to go on the best evidence available, and that's got to at least be 30mm. Or there has to be some other rational engagement with the evidence that is available. Whether or not that would be to give recipients of the guidance a range, an indication of where the evidence lay, and express reference to the fact that further evidence was being sought on this question, which is not said anywhere, either in the guidance or indeed on the website where you find the guidance. So there's nothing to suggest that this stipulation isn't considered to be reliable in the manner that one would expect as a question of law it to be. Can I just give you the references for those cases, just so you have my points on those?
Are they references over and above what's in the Skeleton argument? Because you've given us quite detailed references there.
I don't believe they are. No, I think they're the same ones. But may I just have one moment to double check that? Yes, in relation to refugee action, you have the references in the Skeleton argument. The other decisions I was going to take you to briefly were Bracking itself, which you'll know is the lead decision obviously on PSED, and indeed the conclusion at paragraph 62, in which the court effectively said the wait and see approach of the Secretary of State in that case was insufficient to perform the PSED function. That was about the closure of an ILF fund where lots of people who were otherwise in receipt of funds to assist with their care and support were going to lose it, but may have found that it would be replicated by local authorities who were going to receive the funding that would otherwise be distributed by the fund. And Secretary of State said, well, in those circumstances, we can't tell whether or not this is going to have any implications for disabled people. And the Court of Appeal decided that that wasn't sufficient. And the Secretary of State was not in a position, as she ought to have been, to understand what the equality implications or potential equality implications could be. So we say the same here. If the Secretary of State hasn't, in fact, got the evidence to explain just how dangerous or otherwise 25mm is, he can't be making rather a proper evaluation of the equality impacts, potential or otherwise. That's paragraph 62. And similarly, in the Law Centres Federation case, Mr. Justice Andrews' issue then does something similar in relation to potential impacts of the decision to consolidate housing possession advisory schemes, and the references for that are just 102 and 104. Having established that there was a real risk of equality impacts, which we say were in that place too, it was incumbent upon the Secretary of State to establish what they are to a reasonable degree. And of some note, I was just going to take you to this, is at paragraph 49 of Lady Justice Andrews, Mr. Justice Andrews' judgment, she makes the point that consultation is no substitute for their own inquiries. And so, yes, it's true in this context that Secretary of State did undertake some consultation with RNIB and the others. If the end product of that is there was significant doubt about whether or not 25mm was safe, then it was incumbent upon Secretary of State to understand the potential implications before deploying the guidance. Otherwise, my lady, my lords, you have all the references in relation to the relevant case law in the skeleton argument. So unless I can assist further at this stage, I hope that you have the essence of
Yes.
our case on the appeal. Okay.
Thank you very much, Mr. Speaker. Yes, Mr. Williams.
I read, my lord. My lord, in my submission, the issue in this case can be distilled as follows. Did the Secretary of State act in breach of his duty of inquiries or otherwise irrationally when he published updates to his guidance on tactile paving, which retained the existing guidance on curb heights, in circumstances where A, the Secretary of State had accepted that there was a need for further research on the topic, and B, he had already commissioned such research. In short, was it irrational or in breach of his duty of inquiries to do what he did in the meantime to retain the existing guidance? Now, my lords, my lady, there is no doubt that the claimant and those supporting her have a strong and genuine belief that the Secretary of State's decision was wrong, and that not only it was wrong, that it gives rise to matters of unsafety. But of course, the question for the High Court was not whether the decision was right or wrong, whether it was lawfully open to the Secretary of State. And we say His Honour Judge Jarman KC, who found the Secretary of State had not acted in breach of his duty of inquiries or otherwise irrationally. He was right to reach that conclusion, and his judgment contains no error of law. My lords, my ladies, if I can outline the structure of my submissions, I start by providing an overview of the Secretary of State's case, including 6 overarching points I wish to make. Then I'll turn to the documents, and I know my lords and ladies have read and been taking some of the documents, but there are some points I need to tease out in relation to them. Then I'll address you briefly on legal principles, which are largely uncontroversial between the parties, and then I'll turn to the grounds of appeal. And I had formulated my submissions on the basis of the grounds of appeal, grant of commission, and in the skeleton argument, which I understand, although developed slightly differently, or in a different manner today, are maintained. In terms of the overarching points, as I say, there are 6. The first is this, that the guidance under challenge does not establish minimum curb heights across the public realm. The guidance is concerned with curb heights in limited and specific circumstances. Limited, because the guidance on curb heights is given only in respect of the use of tactile paving. And although there are the 2 guidance documents under challenge, the inclusive mobility guidance under challenge is parasitic on the tactile paving guidance in that regard. And it's specific because the guidance applies in the context of one type of tactile paving only, blister surfaces at pedestrian crossing points. The second point is this, that the broader context is that the guidance documents, both the tactile paving and the inclusive mobility guidance, provide guidance on a wide range of other topics, other than curb heights. The tactile paving guidance, for instance, gives guidance on 5 other types of tactile paving, none of which is under challenge, as well as more general guidance in relation to engagement and drawing attention to equality.
I'm not sure what the legal significance of that is. If, say, a document talks about 10 subjects and it's unlawful on one of those subjects, then why does it matter that it also covers 9 other topics?
You're absolutely right, of course, my lord, but the significance is this, when the Secretary of State was posed with the question, what do we do in the meantime, one of the answers might have been to not publish any further guidance. And if the guidance had focused solely on the issue of kerb heights, that might have been the only rational response. But it didn't. There were a wide range of other matters that both guidance documents addressed, and there was a compelling need to update that guidance in a way that is not controversial between the parties. And that's the relevance in my respectful submission, my Lord. And as I say, that there can be no doubt that there was a need to update this guidance. The tactile paving guidance was first published in 1998 and the inclusive mobility in 2002. And as I say, the vast majority of the updates are not challenged in this court, and as I understand it at least, a number of them at least are welcomed by the claimant and those who support it. The third point is that the 2002 update maintained the existing guidance on kerb heights. And although the formatting and substance change, the style changed, and my Lord picked up a slight difference between the 1998 guidance and the 2022 guidance, the substance of the guidance concerning kerb heights remains materially the same. This wasn't a case of introducing new guidance on the topic of kerb heights. And my Lord, I don't say that that in any way makes this guidance immune from challenge. So this is a case where the challenge should have been brought years ago. That's not my point. The point is this, that the guidance under challenge in these proceedings has been in force for over 2 decades and has been informing decisions on design of tactile paving for 2 decades. And the fact, I do maintain the point that the fact that this was long-standing guidance meant that it was open to the Secretary of State, and certainly not irrational, for him to take the view that that guidance should only be amended where there was a sufficiently robust evidence base to do so. The fourth point is that the issue in respect of kerb heights was conscientiously and carefully considered as part of the process leading up to the 2022 updates, and that's a proposition which I don't think is disputed between the parties, but I want to make good by going through the documents. This is not a case where the concerns raised about the kerb height guidance have been overlooked or ignored, nor is it a case where the Secretary of State misunderstood the available evidence on kerb heights. The Secretary and those advising have grappled with whether the kerb height guidance ought to be amended, and specifically grappled with the UCL research on which the claimant specifically relies. And they came to the conclusion that the available evidence was not sufficiently robust, was equivocal at this stage, and that further research would be needed. That takes me to my fifth point. The Secretary of State has jointly commissioned research into the specific issue of appropriate kerb heights and has committed to reviewing the guidance documents once the findings are received. That research is ongoing. At the time the decision to publish was made in late 2021 or early January 2022 when the guidance documents were published, the expectation was that that guidance would be published by late 2022, early 2023, i.e. about 12 months hence. Now, we know there have been delays, but certainly that was the understanding of the Secretary of State at the time he took the decision to publish the updated guidance. And the Secretary of State has committed to reviewing the guidance once that research, the kerbs and layouts research, has concluded. He made, or his officials made that clear, that was the intention prior to the issuing of the guidance and prior to this challenge, and the position has been repeated in witness evidence before the High Court and reiterated before this court. The sixth and final point is this, that the question of what an appropriate kerb height is calls for a multifaceted judgment.
A what?
A multifaceted
Yes.
judgment. It involves, on one hand, a technical assessment of what the minimum kerb height is detectable, what the minimum kerb height, detectable minimum kerb height is for visually impaired persons. That's a technical assessment, of course. And secondly, it requires a balanced judgment as to what an appropriate kerb height may be, balancing the needs of other street users, including the mobility impaired. And it is my submission that given the nature of the decision under challenge, this court, or the High Court, I made this submission below and I reiterated in this court, should be slow to interfere on Wednesday grounds with the judgment reached by the Secretary of State and those advising him. And so, in light of those 6 submissions, just to very briefly summarise what we say, and then I'll go to documents.
Sorry to interrupt. Can I just ask one question? I think Mr. Burton's submission was that this didn't involve a balance between the potentially conflicting needs of different users, because it's only dealing with limited crossing points, and there are other ways in which the needs of people with mobility difficulties can be dealt with.
I understood that to be the submission.
Yeah.
I have to say that in the might be said to be a cheap point, but in the appellant skeleton argument, it did appear to accept that this was a question of balance judgment, and therefore that was a high threshold of rationality.
I think you can take it that's no longer.
Maybe that's no longer. Sorry, well, if that's no longer the case, then it does call, in my submission, for a balanced judgment. And I'll turn to documents. One clear example is in relation to vehicle crossovers. We've seen that that's one of the instances where the 25mm guidance is given. Well, there's clear indeed a balance there to be struck between the interests of visually impaired, but also the need for a vehicle crossover to function. Because a vehicle won't be able to get over a curb, or may not be able to get over a curb of a higher height than 25mm. And so there is a balanced judgment to be struck, and I'll take my lady to the fact that that balanced judgment was considered as part of the original guidance in 1998.
I think there is quite a serious issue of characterisation between you and Mr. Burton, which I asked Mr. Burton about. He says the decision was, as it were, a positive decision to publish this unqualified recommendation. You are, I think, saying, no, it was a decision not to change the old recommendation.
Absolutely, my lord. I don't say that that did not allow a judicial review claim to be made or take any point on delay. That's not my case. But I do say, as a matter of substance, the decision was to retain that which would have been guidance for over 20 years, pending the conclusions of the ongoing research into curb height.
Yeah, well, that may or may not make a difference, but I can see that it might be said, well, in the absence of robust evidence requiring a change, we leave it as it is, as opposed to saying, well, we can't currently support the 25mm, we better do something else.
And in my submission, my lord, the decision was made was the former, and the question for the court below and for this court was that rational? It really boils down. And that brings me to the summary.
Mr. Williams, sorry, just as a follow-up to my lord, can I just ask you this? One of the grounds that's advanced against you is that there was a failure to comply with the Tameside duty of inquiries. Is it part of your submissions that actually that's exactly what the Secretary of State is trying to do?
Absolutely, my lord.
And you can't, the court should not intervene while it's going on.
My lord, I say that is my submission, but we are furthering our duty under Tameside by undertaking further inquiries. Sometimes Tameside will mean there's an inquiry that one can do quickly and find the answer to and not have to make the decision. But the question for this court was, having the Secretary of State having decided to, consistent with his Tameside duties, undertake further research into the issue, was it nevertheless irrational for him to maintain the existing guidance in the meantime? And that's the way the judge below characterised it. And he found it was irrational. In my submission, there was no error of law in that conclusion. But also, just very briefly then, we say that the Secretary of State was firstly entitled to publish a 2022 update to the guidance documents without having to wait for conclusions on the ongoing research into kerb heights. It wasn't obliged to do so. Secondly, that it was not irrational or otherwise unlawful for him to maintain the existing guidance in the meantime, pending the findings of that research. And thirdly, the fact that the Secretary of State can't point to specific expert or empirical evidence underpinning the original guidance on kerb heights does not render the decision irrational. I submitted below that the 25mm figure was a product of an evaluative judgment. I'll seek to make good that proposition when I go to the documents, if I may. So then, turning to the documents, I will take the court through the documents in three tranches, if I may. First of all, looking at the guidance documents, the current and the previous ones, then looking at how the issue of kerb heights was considered by the Secretary of State and those on his behalf as part of the process of updating the guidance documents. And then, thirdly, to draw the court's attention to the details of the ongoing research and the Secretary's commitment to review that once the research is completed. And starting then, if I may, with the guidance documents under challenge. And we need to look at page 164, if we can, of the claim bundle to start with. My Lord, if I could ask the court to turn to page 170, the introduction. My learned friend's already taken to this, so I can take it quickly, but just some points on this, if I may. Under 1.1, first sentence, this document is a guide to best practice. Now, best practice is highlighted in my learned friend's skeleton and was highlighted in his submissions. But what is it best practice to? It's best practice on the use of tactile paving surfaces. It doesn't purport to give broader guidance. Secondly, point to note is that at 1.2, what's the guidance based on? It notes at the first paragraph under 1.2, the 1998 guidance, and that it does not alter the principles set out in the original guidance. And as Ms. Franks explained in her first witness statement, although the 2022 update did make some important updates, for instance, in relation to the layout and accessibility of the guidance and the introduction of references to the Equality Act and beefing up references in relation to consultation, it didn't make that many fundamental technical changes. And then thirdly, the third point to note is the point at the bottom of the page, last sentence, that the research behind the original guidance involved people with a wide range of other impairments. And that had identified negative effects of tactile paving on the experience of the wheelchair users and people with walking differences. And just 2 points on that. I'd ask the court to note that there was research underpinning the original guidance. I'll come on to what that was in due course. But also that research was cognizant of the fact that there needed to be a balance between the needs of certain types of persons with disabilities and other types of persons with disabilities, the visually impaired and the mobility impaired. And then over the page, if we go on to 171, what does the guidance cover? Well, it covers 6 different types of tactile paving surfaces, we're told at 1.3. And just for your note, my lord, my lady, page 309 of the bundle in the inclusive mobility guidance, there is an illustration of those 6 different types of tactile paving surfaces. So one can see what we're talking about.
I'm so sorry, I didn't catch the
309, just for your note.
Thank you very much.
It's just helpful to have a visual representation of those.
Yes, absolutely. Thank you.
The only section which is challenged at all by these proceedings is the first, the blister surface for pedestrian crossing points. The remaining technical chapters, the remaining 5 technical chapters, there's no concern raised about at all. And when my learned friend draw the court's attention to the last sentence of this guidance. The guidance is intended to be suitable for application to a wide range of common situations. Well, of course, that's true, but that has to be read in light of the preceding section, which indicated what the guidance covered. It was covering guidance on 6 different types of tactile paving. The one we're concerned with is crossing. And if we turn over then to page 179, sorry, no, before we do that, I'm sorry, if we could go to page 172. There is a heading Key Principles at 1.5, and you'll see when we get to each of the technical chapters, there's an introduction which says, and I paraphrase, this technical guidance has to be read in light of the key principles in chapter 1. It might be said that was odious because we have to read it as a whole, but it clearly directs the reader to that fact. And one of the key principles is the principle of inclusive design, and at the last paragraph, it emphasises that the use of tactile paving services and engagement in relation to this as described in section 1.6 should therefore be considered from the earliest stages of proposals and design for streets and spaces in new developments and built environment improvement schemes. This guidance should be referred to from the outset of any public realm design or maintenance scheme. And then over the page at, sorry, not over the page, at page 176, we have then the guidance on engagement and the need for diverse engagement to include those represented people with protected characteristics. I'm reading from the second paragraph here, including organisations of or for vision impaired people. I draw the court's attention to that because His Honour Judge Jarman KC referred to this as being a relevant consideration when considering the rationality of the Secretary's decision. For the reasons I'll come on to, I say that that was a relevant consideration. It was open to the judge to take it into account, but I felt it necessary to take the court to that reference. Turning then on to page 179, and this is chapter 2, blister surface for pedestrian crossing points. And paragraph 2.1, the first sentence under that, indicates the blister surface is for use only at designated pedestrian crossing points, and its purpose is twofold. So, pausing there, the guidance on curb heights, which we'll come to, and which was the subject of this challenge, applies only at designated pedestrian crossing points, because that's the only circumstances where blister surfaces are used. It then comes on to explain its general purpose. The purpose is twofold. Firstly, the general purpose, to provide a warning to vision impaired people who, in the absence of curb upstand greater than 25 millimetres high, may otherwise find it difficult to differentiate between where the footway ends and carriageway begins. And then secondly, a secondary purpose in relation to control of crossing points. But, my lords, we have to read that statement, that stipulation in context. That's in the context of giving guidance on the use of blister surfaces at pedestrian crossing points. And we can see it figure 1 at page 181, how the dropped curb, which will be very familiar to the court, is intended to operate. And we can see from that that the wherever there is a dropped curb, wherever there's a crossing point, that the interface between the carriageway and the pavement will be either flush or no more than a deviation of 6 millimetres. And if we go back to page 179, that is also explained in the text. The critical point is that at designated pedestrian crossing points, i.e. where this guidance will apply, the surface is required to be flush or near flush, which is precisely why blister surfacing is needed. And we can see that from the paragraph 3, while the absence of curb upstand at crossings is essential for wheelchair users, etc. And therefore the blister surface is therefore an essential safety feature for vision impaired people at pedestrian crossing points. That's also, my lords and ladies, confirmed for your note at page 288 of the bundle in the inclusive mobility and guidance, where it says level access at all road crossings is essential for wheelchair users. So the guidance here...
So the point that's being made in this paragraph is that the surface is an essential safety feature. That is to say, the blister paper.
Absolutely. Actually, well, there are two factors essential. One is that at a crossing... So first of all, the context is a crossing point, and there are two essential factors. One, for the mobility impaired wheelchair users, it has to be flush or near flush, no more than 6 millimetres. Two, for the visually impaired, where that's the case, there needs to be blister surface. And what the guidance is concerned with is, as I say, designated pedestrian crossings. And what the guidance is saying is that because at designated pedestrian crossings, there will be no curb upstand, or a curb upstand of no more than 6 millimetres, which won't be detectable, it's essential that blister surface is used as a safety feature. That's what it's saying. It doesn't purport to go beyond that. It doesn't go beyond that.
Mr. Williams, we've heard from the appellant side that this case is not about something that all of us will have experience of in daily life, which is that in modern town centres often there's a new kind of design where the road carriageway is pretty much flush with where pedestrians can walk, and understand there's now a moratorium on that.
That's well, my lord. Actually, the guidance that was promoting that historically, LTN 1-11, has been withdrawn. Right. Ms. Franks gave evidence of that in her first witness statement. My lord, there's a point I was going to come on to, which is sorry, my lord. Did you have a...
Don't take it out of turn at all, please. But I just wanted really, so I can be clear in my own mind what this case is about. You agree, do you, that this case is not about that general phenomenon? This is very specifically about pedestrian crossings where there is the blister surfacing to be used.
That is one of my key points. That was the first proposition, which is this is not about curb heights across the public realm. It's about specific the curb heights in specific and limited circumstances. And in this particular example, I'll take the court to the two other examples, but in this particular example, it's saying because where there's a dropped curb, the curb height's not going to be on any view detectable. You need a blister surface. It's not proportionate to go further than that. And I will shortly take the court to the concept of shared space and explain why that's the case, if I may. Of course. The second then example that is relied upon, the mention of 25 millimetres, comes at page 202 of the bundle. And this is in relation to vehicle crossovers and vehicle accesses. And those the court will be aware, and it's defined if you need a reference at page 244 of the bundle vehicle crossovers is. But these are situations where a vehicle crosses over the footpath with a ramp replacing a curb. And the court will be familiar with these when there's petrol forecourts. That has to happen when there's residential drives. That often but not always happens. And when that's the case, it's indicated that that a minimum 25 millimetres upstand should be provided between the carriageway and the vehicle crossover. The upstand should help ensure vision impaired people do not inadvertently venture into the carriageway. Just to be clear on that, what that means is that where the curb is dropped and there is an interface between the carriageway and the footpath, at that point the upstand should be no less than 25 millimetres, i.e. the part where the car or vehicle crosses over. Not talking about either side of that.
Well, is it where the vehicle crosses over,
Absolutely.
or next to where the vehicle crosses
No,
over?
it's where the vehicle crosses over. My lord, it was actually made clearer in the 1998 guidance, and there's a figure which shows as much, although actually that figure is not before the court. But I've sought instructions on that, and that's well, obviously it's a matter of course to how they read the guidance. But that's
is there a figure somewhere? I mean, I was looking at figure 15 on page 206, which has curb upstands or barriers at the radii. But where do I see that? What, figure 14? Where is that it?
No, as I understand it, my lord, there isn't a figure which shows vehicle crossovers. But over the lunch break, I can find the pages from the 1998 guidance which aren't before you, unfortunately, which shows a figure which showed the same material advice.
So, are you saying that what this is providing for is for a vehicle to mount an upstand
Absolutely.
of 25 millimetres? Well, that's not my experience of petrol filling stations, supermarket car parks, residential driveways, or anything else.
Well,
but
my lord, well, obviously you can take judicial notice of the matters, but it's obviously 25 millimetres, 2.5 centimetres. There is often that lip as to where you drive over. My lord, as I say, over lunch and break, I'll look out at the 1998 guidance, which there was a diagram. I looked at this point, and unfortunately it wasn't included in the bundle. Can I just turn my back? I lost my leg for 1 moment. Now, my lord, obviously, there needs to be a balance struck there between and I made this point earlier, between the need to facilitate the crossover and the helping to provide warning to visually impaired persons. But obviously that is not the only warning that is necessarily in place for visually impaired persons, because where there are vehicle crossovers with high traffic flows, the advice is that blister surface should be used in addition. Obviously where there are low traffic flows, and the judgment is obviously for the particular decision maker in question, or the designer, having regard to the necessary engagement, there wouldn't be blister surfaces. And I'm speculating here, but one would imagine that was to ensure there wasn't a proliferation of blister surfaces, because if there was the blister surfaces every time there was a drop curb where there was a residential access, there would be a proliferation of such surfaces. But again, the key point is that this is providing very specific guidance on a particular point. It's not providing guidance on curb heights across the public realm. And also, ladies, if I just so that advice is consistent with other guidance that is available. And to make good that proposition, we need to go first to page 164 of the supplementary bundle.
of a supplementary.
Yes, of the supplementary. 164. To tab 16. So it's not tab 16, it is tab 25.
Sorry, where are we now?
Tab 25, page 164 of the supplementary.
Yes.
And this is guidance relied upon by the claimant, published in Northern Ireland, and they rely upon it because it makes reference to the 60mm figure from the UCL research. If we look at the bottom of 164, sorry, first of all, the penultimate paragraph, the Department's Principal Design Guide, the Design Manual for Roads and Bridges, gives general guidance on standard heights of curves, which range from 100 to 125 in urban situations and 75 to 100 millimetres in rural situations. DRMB also contains guidance on specific instances where the curb height should be varied from this standard, and says examples would include the provision of curb as highway structures in conjunction with vehicle restraint systems. Well, that's not relevant, but the next is, and the provision of drop curbs at control crossing and pedestrian crossing points at junctions and vehicular accesses. Well, of course, that is exactly the advice that's been given here. And if we turn over the page, we see that the advice is that curb heights at pedestrian crossing points, including both controlled and uncontrolled crossings, should normally be flush with the carriageway, but can range from 0mm to 6mm. That's precisely the same guidance that is provided for in the tactile paving guidance. And then we see at the next paragraph, a 25mm curb height should be used for vehicular accesses. Lower curbs at vehicle access should not be considered an alternative to drop curb facility. My Lord, it's right to say that it goes on to, in the next couple of paragraphs, talk about curb heights at public realm schemes and the lowest being 16mm. But the point here is that the guidance which is under challenge and the specific instances where it references the 25mm stipulation, as my own friend characterises it, is consistent with guidance in other jurisdictions which has had regard to the UCL research. And, well, just for your note, I won't take you through it, but the Phase 1 report, which I fully accept post-dates the decision under the question, which was the exhibit to Miss Frank's second witness statement. I may take my lords to it in due course, but for your note, page 22, there's a table 3.1, and that sets out a number of standards. And the short point is that in a number of those standards, in the DMRB, in the streetscape standards, and in the London cycling design standards, the same advice is given in relation to curb heights at pedestrian crossing points and at vehicle crossovers. And I'm going to turn the court's attention to that in due course, but just for your note now. Then going back into the guidance itself, the final focus of the challenge is back at page 202 of the core bundle. Raised crossings for traffic calming, and happily we do have a figure to explain what that is. That's figure 13 at page 204. And the court will be familiar with this type of intervention into the road to slow down traffic using the road. And you could see there the section at figure 13 that is required to be flush with the tactile paving either side. And then there is, of course, a ramp either side of that, which must taper from flush to the standard curb height. And if we turn them back to 202, we're told under the heading General Layout, where the carriageway has been raised to the level of the footway, the blister surface should be installed on the footway. And then final sentence, where an extensive area of carriageway has been raised, it's not appropriate to install the blister surface along the full length of the raised area. In those circumstances, the blister surface should only apply to the main crossing points. We've seen that from figure 13, where the remaining interface, so that's the area either side of the flush interface between the footway and raised carriageway, is flush or has an upstand of less than 25mm. It's vital to ensure the vision impaired people are not able to stray invertly on the carriageway. That can be achieved by creating a level difference between the footpath and carriageway of at least 25mm, so the transition is not actually flush, or by using an appropriate form of physical barrier. Again, a very specific circumstance in which the guidance is given. And so, just to draw some points out in relation to that, as I say, the guidance does provide guidance in terms of limited and highly specific circumstances. It does not provide or purport to provide guidance on the appropriate minimum curb heights across the public realm. I'm using those words because that's the introduction to my then friend skeleton, which start with the phrase across the public realm. And critically, it doesn't provide or purport to provide any guidance on shared spaces. Now, going back to my Lord Justice Singh's point, can make good that proposition, which I don't think is in dispute between the parties, but to help with what is the design concept underlying shared spaces, we can look at the Women and Inequalities Committee report, which in the supplementary bundle at page 288 And there is a discussion there under the heading, under the heading, what is a shared space? And if I could just invite the court to read paras 157 through to 159. The fundamental design philosophy underlying shared spaces is that to encourage all types of road users to share the full width of the street, that there be a mixing of pedestrians and vehicles in the same street. That's not what this guidance is seeking, the guidance and the challenge, I mean to say, is attempting to do. Quite the opposite. It's intending to provide, and it does provide guidance on pedestrian crossing points. Why is this important? Well, it's important because it's trite that challenges on grounds of failure to discharge duty of inquiries and irrationality are necessarily context specific. And it's an important part of the context here that the Secretary of State was not concerned with guidance which sought to provide general advice on appropriate minimum curb heights, and certainly did not seek to provide guidance on shared spaces. And that was relevant to the decision that it took, the Secretary of State took, to maintain the existing guidance pending the further research that's been undertaken into the broader question of appropriate curb heights. I won't take you to the inclusive mobility guidance because it's common ground that all that does is largely transpose and summarise that which is within the tactile paving guidance. But I would wish to take you to the 1998 version of the guidance, and that is at the supplementary extracts of it rather at supplementary bundle page 46. And we can see if we turn to page 61 in there that materially similar guidance is given in relation to the use of blister surfaces for pedestrian crossing points under the 1.1 purpose and the emboldened paragraph there. Now, the Secretary accepts, as it did before the court below, that it can't point to any specific empirical or expert evidence which underpins the particular stipulation that is found there, the 25mm stipulation. But in my submission, it is wrong to characterise that guidance as arbitrary, as the claimant does. And I say that for three reasons. Firstly, we know that there was research behind the original guidance, which involved people with a wide range of impairments. We've seen that referred to in the current guidance at section 1.2, but it's also, unsurprisingly, referenced in this guidance. If we turn back to page 59, and the second paragraph, the advice in this document is being compiled after full discussion and in full consultation with interest groups and aims to provide consistency in the use of tactile paving services throughout the country. So, first point, we know the guidance was based on research which involved people with a wide range of impairments. Secondly, we know that the research included visually impaired persons and people from groups who represented their interests, such as the RNIB. And we know that from Ms. Fothergill's witness statement. And if I could ask the court to turn to page 175 of the supplementary bundle. And Mr. Fothergill helpfully gives background to the earlier guidance on tactile paving at paragraphs 11, and then refers to the 1998 guidance at paragraph 12. And then over the page, paragraph 13 is the key point. RNIB, represented at the time by the Joint Mobility Unit Access Partnership, in association with the Guide Dogs for Blind Association, assisted with this research, and the 1998 guidance was drawn up in full consultation with the Access Partnership and with our full support. And the third point is that we know that specific consideration was given to the issue of kerb heights when the 1998 guidance was first produced. And to make good that proposition, if I turn the court's attention back to the 1998 guidance, and at page 62, and this is over the page from the page we were looking at previously with the 25mm stipulation. And if I read from the third paragraph, a detectable kerb upstand prevents visually impaired people from unknowingly stepping off the footway into the carriageway. If there is no kerb upstand, some other readily identifiable indicator must be used. And then it says why tactile surfacing has been developed to provide a warning. And then it goes on to say this, the penultimate paragraph. Alternative approaches to the installation of tactile surface were suggested, most notably the concept of creating a lower kerb with a small upstand, which would both allow access for wheelchair users and provide a warning for visually impaired people. This idea was not accepted because no optimum upstand could be identified, which could meet effectively the needs of both groups of people. It's implicit from that, that as part of the research, specific consideration was given to what a detectable kerb height was. And so, whilst I'm not able to point to any specific empirical or expert evidence, the claimant's position that the stipulation of 25mm is arbitrary, it is simply wrong. It is clear, as I submitted before the court below, that an evaluative judgment has been reached in respect of that matter. Well, as I move from the guidance to the how the issue of kerb heights was considered as part of the updating process, and my lords, for this, I'll use my skeleton argument as a prompt, if I may. And we need to turn first of all to paragraph 20 within my skeleton argument. I have a heading there, something there. Consideration of the issue of kerb heights, including detailed research as part of the review and redraft project. And as I understand it, there's largely no dispute between the parties on the fact that it was considered by the Secretary of State. The question is, for this court, is what the Secretary of State did with it a rational conclusion? But briefly running through this, we start at 21.1 with the first research project undertaken by TRL, the purpose of which was to understand whether the guidance needed updating, and if so, the scope of that update. And that was undertaken between November 2017 and July 2018. And the point, as I make over the page at page 8, is that the UCL research was considered as part of that very first stage of the updating process. The UCL research was considered as part of the literature review, and I cite the relevant section there. Having noted the conclusions that the UCL research came to on detectable kerb heights, the authors highlighted the limitations of that research, primarily that it did not consider the impact of kerb on the mobility of wheelchair users and other people who have difficulties walking. So those instructed on behalf of the Secretary of State were alive to the UCL research at an early stage. And that was important at some part of this process, early on in the pleadings, it was suggested that the Secretary of State had not considered or grappled with this, the UCL research. That's not maintained. Clearly, it was grappled with, and it was grappled with from the very first stage of it. We then have the second research project undertaken by TRL, which took place between November 18 and February 2020, and that was a further research into specific areas. It consisted of a literature review, of site visits, of user surveys, and of workshops. And if I just draw the court's attention to the output of that research, which is at page 490 of the supplementary bundle. Well, actually, it starts at page 482, but it is then page 490 that I draw the court's attention to. This section, the consultants were reviewing the guidance on tactile paving, and as we see, if we look at the headings, it set out the research questions that were being posed. At 3.2, the methods that were considered. At 3.3, the findings, and at 3.4, the recommendations. And we can see, if we turn over to page 494, just under the chapter 4, section 4, it says under the bullet point list, more information about these recommendations and propositions, including potential revisions to the structure of the guidance, is provided at Appendix B. We'll come to that in a moment. And that the proposed changes would represent an evolution and simplification of the current practices rather than requiring current infrastructure to be replaced. We then go to Appendix B, and we need to look at page 527. Recommendations and propositions for revised guidance on tactile surfaces, and we look over the page at 528. And what they have done here is gone through the 1998 guidance section by section, the technical section, well, no, not just the technical section, they looked at all sections, but this is technical section by technical section, and looked at the tactile paving surfaces, that's the bottom of page 528. And in relation to the revised core surface at page 529, the advice was to retain that core statement, including retention of the stipulation in question. Now, it is right to say that there was an asterisk which said that the question of whether 25mm retains an appropriate boundary between what is and is not flush should be the subject of further consideration. But it's important in my submission that TRL here, who were cognizant of the UCL research, weren't saying at this stage to the Secretary of State, our advice to you is you remove that stipulation. They were saying it needs further consideration. And of course, the Secretary of State, by the time he got this report, because this report was published in 2020, had already jointly commissioned research into, amongst other things, the issue of appropriate curb heights. That's the inclusive design research. And for your note, my lords, that I deal with, well, Ms. Frank, addresses in her witness statement for your note at page 36 of the supplementary bundle. And then she appends extracts of that inclusive design research at tab 9, page 70 of the bundle. Now, this research was published in February 2021, so was available to the department before it began undertaking the redraft, or when it was undertaking the redraft of the guidance documents. And I'll just, if I may, take the court through a number of references in here and then make some points in relation to it. Firstly, page 77. We have an executive summary an introduction and background, and we can see from 1.1.1 that it was a joint a project jointly commissioned between Transport Scotland, the Scottish Government, and the Department for Transport. And we can see from 1.1.2 and 1.1.3 that it was taken in parallel with the TRL second research project that I have just taken the court to. And at 1.1.3, both research studies have been designed to be complementary without significant overlap of content. And then if we look at the recommendations at page 107, starting at 107, there are a number of recommendations relating to questions of inclusive physical design measures. That started at 107, but then the critical page is the page that my own friend took you to, which is page 111. And this was under the heading Principle 13, Segregation Inclusive Physical Design Measures. It looked at a whole host of other matters, but for our purposes, this is what was relevant. And the sub-principle, Principle 13 is that disabled street users access conditional on physical street design features that are conspicuous, legible, comprehensive, and credible. And at 13.1, sub-principle 13.1, all disabled street users value some form of curb demarcation to define the pedestrian place and demarcate it from the vehicle place. And then it came to a recommendation. My law's been taken through that. And the recommendation was that there was for further quantitative research to be undertaken. And finally, the research should seek to identify the curb height that supports access for the majority of users. 8.5.3, I'd ask the court to underscore this. This research considered the available research and concluded a firm recommendation on curb heights could not be made without further research on A, and that's my A, sorry, curb height in real world conditions, and then B, with a broader range of disabled street users. And it went on then to reference the Pamela or UCL research at 8.54, 8.55. Before making some observations on that, which I will do in a moment, I just draw the court's attention to the literature review, which fed into that recommendation. That is, it starts at page 117, but the key element for us is at page 122. And there's a heading Curbs and Levels.
Just before we look at that, I mean, the point that's taken against you on 8.5.3 is that the guidance does make a firm recommendation.
Sorry,
the guidance, the issued guidance does make a firm recommendation of 25 millimetres. That's the point that's being put against you.
Absolutely, I appreciate that, my lord. But what the point I was taking the court to this for was to illustrate that, notwithstanding the fact that the authors of this were aware of the UCL research and other research we'll come to the court to, it concluded the available evidence wasn't sufficient to make a firm recommendation. And the question then was, what should the Secretary of State do about it? Well, what it's done about it is commission further specific research into that very point. The question then becomes, what should it do in the interim? The question for this court was the maintenance of the guidance rational or not? And I'll come to that when I come to my ground, if I may, but that's the way in which I have conceptualised this challenge, at least. The Secretary accepted that the available evidence was equivocal. I'll take you to that. He understood that, and the question for him is, what do I do in the meantime? The literature review, Curbs and Levels. If I can ask the court to read the first paragraph and then the fourth paragraph. I'm not seeking to cherry pick there. I don't think there's anything in paragraphs 2 and 3 which are particularly relevant. So first and fourth one, I asked to do that.
First and which paragraph?
The fourth, the beginning with there was a concern from older people.
Yeah.
And the real key of that is the final sentence. And but also the authors of this report were aware and grappled with the results of the UCL research, but they were also aware of research which pulled in the other direction. There was research that indicated that kerbs could be a trip hazard in human research. There was also caution expressed about reliance on the UCL research because it didn't take account of real-world conditions. And the point, which is a point that is on a Judge Jarman picked up below, is that that doesn't just act in one way. It isn't necessarily the case, that real-world conditions mean that the detectable kerb height will be higher. There may be additional stimuli, which means that the detectable kerb height is different. And that's the caution that was expressed by Parkin and Smithies in the 2012, and which is one of the reasons why the recommendation of the authors of this report was to undertake further research into real-world conditions, i.e. what are the detectable kerb height there, not simply accept the UCL research provided the answer to detectable kerb heights and look at the balance question, i.e. what impact would that have on other street users. But also, the number of points to make in light of that. The conclusion, as you've seen, of this research was that the available evidence was not sufficient, that the authors of this report were able to make a firm recommendation on kerb heights, and that was the case even though they had had specific regard to the UCL research. That was consistent, of course, with the conclusions of the TRL research. Secondly, they recommended that further research was necessary to consider appropriate kerb heights in real-world conditions and with a broader range of street users. And thirdly, as I have said, there is other research which at least called into question the applicability of the UCL research. And therefore, this inclusive design research supports the ultimate conclusion of the Secretary of State that the available evidence on the issue of kerb heights was equivocal. My Lord's question was then, it begs the question, well, what do you do about that? And the Secretary of State's response was to commission further, in accordance with the recommendation, was to commission further evidence in respect of it. Just to complete the picture, I see that it's my Lord, I can probably cover one more point before lunch. If we turn back to my skeleton argument,
yes,
at page 8.
404 of the bundle.
Sorry, page 8 of my skeleton argument.
Yeah.
Oh, yes, I'm sorry, I had it loose. I'm very sorry. There then followed the redraft project, and by the time of the workshops in April 2021, of course, the redraft project, which was undertaken by TRL, had the benefit of the inclusive design report. There is no dispute between the parties that the UCL research was grappled with as part of that project, and over the page 9, in particular, specific consideration was given in May 2021 by a meeting of the steering group to the issues that were raised at the the workshops. And just to make good that point, if we could go to page 548 of the bundle, which we can do this hopefully just before lunch.
Which bundle?
Supplementary bundle, I'm sorry. This is the consultation report produced by TRL at page 548 under the...
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Well, Mr. Williams, I think normal business probably means we should stop there.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
We'll sit again at 2.
Thank you.
Court rise, if able.